In 1994, an environmental impact assessment notification was issued by the Ministry of Environment and Forests, requiring environmental clearances before the establishment or expansion of projects in a range of industries. Unfortunately, however, the law was not well known and was not initially implemented strongly, and so a series of extensions were granted, ultimately until 2002. A range of major manufacturers did not comply with these deadlines, in some cases for many years. They were ultimately issued with ex post facto environmental clearances, so clearances which operated retrospectively, and then they were granted further environmental clearances when they expanded. A number of these industries were operating in the Ankleshwar region in the state of Gujarat. A challenge was mounted against these ex post facto clearances. The argument was that these industries, which should have known better, had operated for many years without any environmental clearances at all, and that there was in fact no power to grant ex post facto environmental clearances. Essentially, this was public interest litigation in order to support compliance with environmental regulations. The Supreme Court of India found that ex post facto environmental clearances were unlawful, and as a result, all of these enterprises operated for many years without environmental clearances. Writing for the court, Dr. Justice Dhananjaya Chandrachud stated, "The concept of an ex post facto environmental clearance is in derogation of the fundamental principles of environmental jurisprudence. It is detrimental to the environment and could lead to irreparable degradation. The reason why a retrospective clearance or an ex post facto clearance is alien to environmental jurisprudence is that before the issuance of a clearance, a statutory notification warrants a careful application of mind, besides a study into the likely consequences of a proposed activity on the environment." His Honour continued, "Allowing for an ex post facto clearance would essentially condone the operation of industrial activities without the grant of a clearance. In the absence of a clearance, there would be no conditions that would safeguard the environment. Moreover, if the clearance was to be ultimately refused, irreparable harm would have been caused to the environment." At the same time, the court did not want to shut down productive industries which employ hundreds of people. As a result, the court imposed heavy fines on each of the companies, with the fine monies to be spent on environmental projects in the Ankleshwar region.